welcome to this podcast on English property law. We will cover the basic elements of property law as they relate to the study of English law for undergraduate law students and those taking the Solicitor's Qualifying Examination, the SQE. This podcast was prepared by Dr. Yannis and is narrated by an AI voice. If you would like to know more about how this podcast was produced, get in touch with Dr. Yannis. Let's get started by presenting the general principles of property law. Introduction. The study of property law encompasses the analysis of property as a legal concept. It explores key themes, questions, and ideas pivotal throughout the subject. Cornerstone of modern property law is the 1925 legislative reforms, which transformed the law governing unregistered land. Understanding unregistered land provides a contrast to the modern registered system, offering a critical context for the evolution of property law. Studying property law. Property law is a structured yet intricate subject, demanding a disciplined approach and conceptual reasoning. Key distinctions such as registered versus unregistered land, legal versus equitable rights, and proprietary versus personal rights are foundational. For example, registered and unregistered titles are governed by distinct legal frameworks. While the focus today is predominantly on registered land, knowledge of unregistered land offers a comparative perspective. Property law, though perceived as challenging, intertwines historical and statutory elements, creating both complexity and coherence. It reflects society's relationship with land, addressing competing rights in a resource-limited environment like England and Wales. The study requires an appreciation that property signifies legal relationships over things, not the things themselves. In land law, this includes ownership, use, and state interactions. The Human Rights Act 1998, HRA 1998, further complicates property law, requiring compliance with the European Convention on Human Rights. Cases such as those concerning adverse possession illustrate the tension between statutory principles and human rights. 4 key questions. Addressing land law problems involves 4 critical questions. Is the title registered or unregistered? What property interests exist in the land? Are these interests legal or equitable? Steps being taken to protect these interests. Historical and statutory contexts, alongside case law interpretations, guide the resolution of these questions. Key concepts. The 2 axioms of English property law. Legal rights. Bind the world. Legal property rights impose obligations on everyone, reflecting their universal enforceability. Equitable rights bind. All except equity's darling. Equitable rights bind everyone except a bona fide purchaser of legal estate for value without notice, emphasizing equity's reliance on fairness and good conscience. The 4th dimension of land ownership. Derived from feudal tenure, the concept of estates introduces time as a dimension in land law. Estates determine the duration of land rights, distinguishing between freehold and leasehold estates. The fee simple absolute in possession and term of years, absolute, are the 2 estates recognized at law, governed by the Law of Property Act 1925. Formalities in property transactions. Property interests are generally acquired through transfer or grant, necessitating formalities to ensure legality. These statutory requirements include: contracts for land must comply with Section 2 of the Law of Property, Miscellaneous Provisions, Act 1989. Conveyances of legal interests require deeds under Section 52 of the Law of Property Act 1925. Equitable interests must be created or disposed of in writing, as per Section 53 of the Law of Property Act 1925. Equity addresses the potential for injustice through doctrines like Proprietary Estoppel, which enforces informal agreements under specific conditions. 1925 reforms and unregistered title. Background and objectives. The 1925 reforms aimed to simplify land transactions by reducing the complexity of inquiries into third-party rights. These reforms introduced mechanisms such as overreaching, the registration of land charges to balance the interests of purchasers and third parties. Overreaching allows purchasers to acquire land free of equitable rights. transferring these rights to the sale proceeds. This mechanism facilitates trust asset sales while safeguarding beneficiaries' interests. Land Charges Registration. The Land Charges Act in 1872 introduced a registration system for unregistered titles, requiring equitable interests like estate contracts and restricted covenants to be registered against the landowner's name. Failure to register renders such interests unenforceable against purchasers for value. Doctrine of notice. Registration or overreaching does not apply. The doctrine of notice determines enforceability. A purchaser is bound by equitable interests, lest they are a bona fide purchaser without notice. Actual, imputed, and constructive notice govern this principle. Conclusion. Understanding the evolution of property law principles from the 1925 reforms to the modern emphasis on registered land is essential for comprehending contemporary land law. By addressing the tensions between legal certainty, equity, and practical considerations, property law continues to adapt to societal and economic changes. Registration of title. Introduction. Registration of title marks a fundamental shift in property law, prioritizing simplicity and certainty in land transactions. The Land Registration Act 2002, LRA 2002, introduced reforms that built upon its predecessor, Land Registration Act 1925, LRA 1925, with a focus on technology, efficiency, and modern conveyancing needs. This topic examines the principles underpinning title registration, the changes brought by LRA 2002, the treatment of third-party rights, highlighting the balance between legal certainty and the practical complexities of property law. Key principles of registered title. The system of registered title is founded on three main principles. The mirror principle states that the land register should reflect all the significant facts about a title, allowing purchasers to rely on it without further inquiries, although the existence of overriding interests challenges this principle, as some rights bind purchasers despite not being recorded on the register. The certain principle keeps trusts off the register to simplify conveyancing, with overreaching mechanisms transferring beneficial interests to sale proceeds. The assurance principle ensures that the state guarantees title accuracy, providing compensation for losses arising from registration errors. Despite these principles, critics argue that the mirror is cracked, the curtain ripped, and the insurance expensive. These criticisms underscore the ongoing challenges in achieving a seamless registration system. Features and reforms under LRA 2002. LRA 2002 aimed to modernize title registration through enhanced use of technology, title by registration, compulsory registration, refined overriding interests, a reformed approach to adverse possession, and a new dispute resolution mechanism. Enhanced use of technology refers to the Act's vision of electronic conveyancing to streamline transactions by collapsing multiple stages into simultaneous completion and registration. Although delays in implementation have occurred and efforts toward e-conveyancing continue, title by registration reflects the departure from the traditional approach of merely recording pre-existing ownership, indicating that registration itself confers title. Compulsory registration arises when certain trigger events, such as land sales or leases exceeding 7 years, mandate registration to increase transparency and legal certainty. Defined overriding interests include the narrowing of categories under LRA 2002, emphasizing their limitation to situations where registration is impractical. Adverse possession faces stricter requirements for claiming rights over registered land, reducing reliance on unregistered claims. Dispute resolution is handled by a new office of the adjudicator, later integrated into the property chamber of the first-tier tribunal, which resolves conflicts over registered land. Categories of interests in registered title. Interests in registered title fall into three primary categories. Registrable interests refer to legal estates such as freeholds, leases over 7 years, and legal mortgages, all of which must be substantively registered to be enforceable. Protectable interests include equitable rights such as restrictive covenants and estate contracts. which require registration through a notice or restriction to secure priority. Overriding interests bind purchasers despite not appearing on the register, encompassing short legal leases, implied legal easements, and interests coupled with actual occupation. Under LRA 2002, overriding interests are subject to stricter requirements designed to reduce their impact on the register's reliability. Overriding interests and actual occupation. The treatment of actual occupation illustrates the nuanced balance between protecting third-party rights and ensuring purchaser confidence. Only rights associated with occupation at the time of disposition can override, yet unprotected rights, such as family equitable interests not subject to overreaching, may still bind purchasers if coupled with discoverable occupation. Purchasers must conduct careful inspections to identify unregistered rights, and the courts have explored actual occupation extensively, emphasizing permanence and continuity in establishing overriding status. Case law, including Williams-Glenn's Bank v. Boland and Link Lending v. Bustard, demonstrates the evolving criteria for actual occupation, reflecting its dependence on factual circumstances. Challenges and critiques. While LRA 2002 represents significant progress, challenges persist. Retaining overriding interests continues to undermine the mirror principle and complicate transactions. Practical implementation issues arise due to delays in e-conveyancing and the difficulty of transitioning from unregistered to registered systems. Equitable principles also pose challenges, as the interplay between legal rules and doctrines, such as proprietary estoppel, can complicate the clarity of registered title. Conclusion. The system of registered title under LRA 2002 embodies a modern approach to land law, balancing legal certainty, practical needs, and equitable fairness. By refining principles, introducing technology, and addressing historical shortcomings, the Act strives to simplify conveyancing while respecting the nuanced realities of property rights. Nonetheless, achieving a truly conclusive and efficient registration system remains an ongoing endeavor. Co-ownership and trusts of land. Introduction. Co-ownership occurs when two or more individuals have simultaneous rights of possession to the same land. Common examples include married couples purchasing a home or siblings inheriting property. In all cases of co-ownership, the land is held under a trust, a key legal concept involving the division of ownership between trustees, legal owners, and beneficiaries, equitable owners. This distinction underpins the entire framework of co-ownership and trusts of land. Historically, the Law of Property Act 1925, LPA 1925, imposed a statutory trust for sale in cases of co-ownership, prioritizing the liquidation of land into monetary proceeds. This framework evolved with the Trusts of Land and Appointment of Trustees, Act 1996, TLATA 1996, which replaced trusts for sale with trusts of land, offering greater flexibility and aligning with modern property use. Forms of co-ownership. Under English law, there are two forms of co-ownership: joint tenancy and tenancy in common. Joint tenancy. Joint tenants share an indivisible interest in the entire property. Its features include the right of survivorship, which means that upon the death of a joint tenant, their interest is absorbed by the surviving co-owners until only one owner remains, and the absence of individual shares, which means joint tenants cannot independently dispose of their interest via a will. Tenancy in common. In contrast, tenants in common hold distinct shares in the property, featuring defined shares that can be proportionate to each co-owner's contribution, and the absence of a right of survivorship, which means that shares pass under a will or intestacy. At law, co-ownership can only exist as a joint tenancy. However, in equity, the interest may be held as a joint tenancy or a tenancy in common, determined by factors such as the four unities: time, title, interest, and possession. Creation of co-ownership. Co-ownership can arise through express or implied trusts. Express trusts are formed via formal declarations, typically evidenced in writing under Section 53, 1. B. LPA 1925, and dictate the co-ownership terms. Implied trusts, which include resulting or constructive trusts, may arise in the absence of an express trust. Resulting trusts often reflect direct financial contributions to the property's purchase, while constructive trusts consider indirect contributions or common intention. Severance. Severance is the process of converting a joint tenancy into a tenancy in common, typically to avoid survivorship. Methods include written notice under Section 36(2) LPA 1925, where a joint tenant can serve notice of their intent to sever, and mutual agreement or conduct, where agreements or actions implying individual ownership interests can affect severance. Severance may also occur through alienation by selling or mortgaging one's interest, and unilateral acts such as bankruptcy or other significant legal changes. Reforms under Tlata, 1996. Trusts of land and appointment of trustees. Act 1996 abolished the doctrine of conversion and the duty to sell under trusts for sale, granting trustees broader powers, including the discretion to sell or retain land, subject to the terms of the trust, the beneficiaries' interests. Key provisions include consultation. Trustees must consult beneficiaries and consider their wishes where practicable under Section 11. Applications to court, whereby beneficiaries or trustees can apply to the court under Section 14 for directions concerning the trust's administration. Section 15 requires courts to consider factors such as the purpose of the trust, the beneficiary's intentions, and the welfare of any dependents. Beneficiaries' rights. Under Sections 12 and 13, Tlata 1996, beneficiaries have a statutory right to occupy trust property, subject to reasonable restrictions. Courts balance this right against competing interests, such as creditors' claims. Case law and judicial approaches. Landmark cases illustrate the evolving approach to co-ownership. Stack v. Dowden, 2007, and Jones v. Kernot, 2011, established the presumption that equity follows the law in determining ownership interests, subject to rebuttal through evidence of common intention. Lloyds Bank v. Rossett, 1991, highlighted the narrow criteria for establishing beneficial interests in sole ownership cases. Conclusion. Co-ownership and trusts of land represent a complex interplay between statutory frameworks, equitable principles, and practical considerations. The reforms under Tlata 1996-6 marked a significant departure from traditional doctrines, reflecting the changing nature of property ownership. Understanding the distinctions between joint tenancy and tenancy in common, mechanisms of severance, and the rights of trustees and beneficiaries is essential for navigating this area of law. Landlord and tenant, the law of leases. Introduction. The law governing landlords and tenants centers on leases, a foundational property law concept. A lease confers both proprietary and contractual rights, enabling tenants to occupy land while creating obligations for landlords. This topic focuses on fundamental principles of leasehold law, addressing distinctions between leases and licenses, creation and termination of leases, and enforceability of covenants. Key distinctions: leases versus licenses. A lease is a proprietary right, granting exclusive possession of land for a fixed term and binding third parties. In contrast, a license is a personal right, often contractual, that permits land use without creating a property interest. Courts emphasize substance over form, beyond labels to determine whether an agreement constitutes a lease or a license. In Street v. Mountford, 1985, Lord Templeman outlined the essential elements of a lease: exclusive possession, fixed term, and rent. Characteristics of a lease. Exclusive possession allows tenants to exclude others, including landlords, from the property, unless expressly reserved by agreement. A fixed term requires that a lease have a defined duration, ascertainable at the outset. Periodic tenancies, renewed automatically, meet this requirement. Rent, although customary, is not legally essential for creating a lease. Burn Anstalt v. Arnold, 1989, and non-monetary considerations such as peppercorn rent may suffice. Creation of a lease. Leases can be legal or equitable, depending on compliance with formal requirements. Legal leases are governed by the Law of Property Act, 1925, and must be created by deed for terms exceeding 3 years, S.52, be substantively registered if exceeding 7 years, S.27, FLK 2002, and satisfy formalities unless exempt under S.542, LPA 1925. Example leases under 3 years at market rent. Equitable leases arise when formalities for legal leases are unmet, but satisfy S.2 of the Law of Property, Miscellaneous Provisions. Act 1989, binding third parties when registered or coupled with actual occupation, thereby creating overriding interests. Schedule 3, Para 2, LRA 2002. Agreements for leases are enforceable through specific performance. The Wolf v. Lonsdale. 1882. Termination of leases. Leases may be terminated by notice, which is required for periodic tenancies, must typically align with the payment period. Forfeiture allows landlords to terminate for tenant breaches if the lease contains a forfeiture clause requiring compliance with S.146 LPA 1925 and allowing tenants time to remedy breaches. Relief against forfeiture may be granted to prevent disproportionate penalties. Surrender ends a lease by mutual agreement, formalized through a deed or implied by conduct. Merger occurs when leasehold and freehold interests unite under one person. Leasehold covenants. Covenants are promises made by landlords and tenants regarding land use and may be positive, requiring action, or negative, prohibiting actions. These promises can run with the land, binding successors if they touch and concern the land. Landlord and tenant covenants. Act 1995 simplified the enforcement of covenants in post-1995 leases by replacing privity of contract with privity of estate. Statutory protection also arises under S.19. 1. Landlord and Tenant Act 1927, which provides that landlords cannot unreasonably withhold consent for lease assignments or subletting. Reform proposals. Criticisms of leasehold law, complexity, lack of coherence, and potential for injustice prompted reform proposals. The Law Commission's 2006 report recommended a statutory framework prioritizing fairness, transparency, and judicial oversight in termination proceedings. Conclusion. The law of leases underscores the interplay between proprietary and contractual principles. Understanding the distinctions between leases of licenses, mechanisms for creation and termination, and the enforceability of covenants is crucial for navigating landlord-tenant relationships. Proposed reforms aim to address historical challenges while balancing the rights and obligations of landlords and tenants. Proprietary Estoppel. Introduction. Proprietary Estoppel has evolved significantly over the past 30 years, becoming an essential doctrine within property law. It serves as a flexible remedy where strict legal rights fail to address equitable concerns, often circumventing formalities in property transactions or addressing unconscionable conduct. Proprietary estoppel also plays a critical role in cases where no consideration exists, functioning as an exception to the principle, equity will not assist a volunteer. Elements of proprietary estoppel. The doctrine comprises 4 essential elements: representation or assurance, reliance, detriment, and unconscionability. Representation or assurance requires the defendant to have made a representation or assurance, explicitly or implicitly, about the claimant's entitlement to a property right. The assurance can range from a single clear statement to conduct that creates an impression, as seen in Gillette v. Holt, 2001. Reliance demands that the claimant act on the assurance, altering their position in reliance on it. Courts presume reliance when an assurance exists, unless the defendant can rebut this presumption. Greasley v. C. Cook, 1880. Detriment requires the claimant to suffer a disadvantage or incur a loss due to reliance on the assurance. Detriment is broadly defined, encompassing financial expenditure, personal sacrifices, or changes in lifestyle. Grant v. Edwards, 1986. Unconscionability means that the defendant's conduct must make it unconscionable to deny the claimant's rights, and it remains the cornerstone of proprietary estoppel, as emphasized in Taylor Fashion's Limited C. Liverpool Victoria Trustees, Co. Limited, 1982. Remedies. Courts exercise broad discretion in determining remedies, seeking to achieve justice on a case-by-case basis. Remedies aim to satisfy the equity arising from the estoppel and include several approaches: expectation-based remedies, detriment-based remedies, proportionality, and the minimum equity to do justice. Expectation-based remedies fulfill the claimant's expectations, such as transferring ownership of property. Pascoe v. Turner, 1979. Detriment-based remedies compensate the claimant for their losses, often through monetary awards. Campbell v. Griffin, 2001. Proportionality is required to ensure that remedies are balanced against the detriment suffered, as seen in Jennings v. Rice, 2002. Minimum equity to do justice provides the least burdensome remedy necessary to address the unconscionability. Sledmore v. Dalby, 1996. The Supreme Court in Guest v. Guest, 2022, clarified the remedial approach, emphasizing the need to prevent or undo unconscionable conduct. It is generally aligned with the claimant's expectations, less disproportionate to the detriment incurred. Impact on third parties. Section 116 of the Land Registration Act 2002 confirms that proprietary estoppel creates an equitable interest capable of binding successors in title. In registered land, this interest can be protected by notice or actual occupation, while in unregistered land, binding third parties depends on notice principles. Relationship with constructive trusts. Proprietary estoppel often overlaps with constructive trusts, particularly in cohabitation disputes. While constructive trusts focus on the parties' shared intentions, proprietary estoppel emphasizes reliance and detriment. Doctrines can coexist, operate under distinct principles. Case law. Proprietary estoppel is a doctrine rich in case law, including Thorne v. Major, 2009, recognized implied assurances through conduct in a familial context. Pope v. Yeomans Row Management Limited, 2008, which highlighted the limits of proprietary estoppel in commercial settings. Let v. Holt, 2001, which emphasized the holistic evaluation of assurance, reliance, detriment, and unconscionability, and Sugid v. Sugid, 2012, which reiterated the role of proportionality in determining remedies. Examination tips. Key considerations include focusing on the elements of proprietary estoppel, ensuring each is clearly addressed, analyzing remedies carefully by linking them to the facts of the case, differentiating proprietary estoppel from related doctrines like constructive trusts, applying case law to illustrate key principles and remedies. Conclusion. Proprietary estoppel exemplifies equity's role in addressing gaps in formal property law. By balancing reliance, detriment, and unconscionability, the doctrine ensures fairness in diverse contexts. However, its discretionary nature, broad remedial scope, require careful judicial analysis, exercising proportionality and justice in individual cases. Easements and profits Andre. Introduction. Easements and profits. Rendra are significant property rights, granting individuals the ability to use or derive benefits from others' land. Easements are typically more important in practice and include rights such as access, light, and water, whereas profits involve taking natural resources like fish, timber, or crops from the Serbian land. Understanding the creation, enforcement, limitations of these rights is essential for managing property transactions and disputes. Characteristics of easements. An easement is a proprietary right that benefits a dominant tenement and burdens a servient tenement, dealing with the land and binding successors. According to Re Ellenborough Park, 1956, 4 essential criteria define an easement. First, there must be dominant and servient tenements, meaning easements must attach to a dominant tenement, benefiting it, and burden a servient tenement, with no easement existing independently of land ownership. Second, the right must accommodate the dominant tenement by enhancing its enjoyment, as seen in Moody v. Steggles, 1879. Third, there must be diversity of ownership or occupation, with the dominant and servient tenements owned or occupied by different parties. Fourth, the right must be capable of being subject to a grant, meaning it must be sufficiently defined and cannot amount to exclusive possession. Creation of easements. Easements can be created expressly or impliedly, may exist at law or in equity. Legal easements must be held for an interest equivalent to a fee simple or leasehold absolute in possession, be created by deed under Section 52 of the Law of Property Act 1925, and be substantively registered under Section 27 of the Land Registration Act 2002. Equitable easements arise where legal formalities are unmet, but the requirements for a specifically enforceable contract under Section 2 of the Law of Property. Miscellaneous provisions. Act 1989 are satisfied. Its implied creation takes several forms. Easements of necessity arise where they are essential for land use, such as providing access to a landlocked parcel. Easements implied by common intention occur where the parties' intentions require an easement for proper land use, as in Wong v. Beaumont, 1965. The rule in Wheeldon v. Burroughs implies quasi-easements enjoyed before division of ownership if they are continuous and apparent, necessary for the reasonable enjoyment of the land. Section 62 of the Law of Property Act 1925 converts licenses or privileges into legal easements upon conveyance. Extinguishment of easements. Easements may end through unity of ownership. The dominant and servient tenements come under single ownership. Through release may be express or implied, including prolonged non-use with intent to abandon, or through frustration if changes make the easement unfeasible, as seen in Huckvale v. Edbian Hotels, 1989. Enforcement and registration under LRA 2002. Legal easements created by deed override first registration and subsequent dispositions if they are discoverable or used within a year before the transfer, as set out in Schedule 3 of the Land Registration Act 2002. Executable easements require registration by notice to bind future purchasers. Implied legal easements maintain overriding status, but are limited by the discoverability requirement. Profits à prendre. Profits grant the right to remove natural products from another's land, such as fish or timber. Unlike easements, profits can exist in gross, without attaching to a dominant tenement. They can be created and extinguished similarly to easements, but are often less regulated in practice. Reform proposals. The Law Commission's 2011 report proposed clarifying and simplifying easement law, including limiting the operation of Section 62 to avoid unintended creation of rights. Although reforms have not yet been implemented, they reflect ongoing concerns about the complexity and unpredictability of easement law. Conclusion. Easements and profits. Prendre represent vital mechanisms for balancing land use and ownership rights. Their nuanced legal framework requires careful application to ensure fairness while maintaining clarity in property transactions. Freehold Covenants. Introduction. Freehold covenants are agreements made between neighboring landowners concerning the use or non-use of land. These covenants, enforceable under contract law, are made by deed and bind the original parties. However, for such covenants to bind successors in title, complex rules must be satisfied under common law and equity. Similar to easements, freehold covenants establish a relationship between two parcels of land. The dominant tenement benefits from the covenant, while the servient tenement is burdened. Covenants are classified as either positive, requiring some action, such as maintaining a fence, or negative, restrictive, prohibiting certain activities, such as conducting a business on the land. The enforceability of covenants becomes intricate when land changes ownership, necessitating an understanding of how benefits and burdens run with the land. Passing of the benefit. The benefit of a covenant can pass under both common law and equity. Common law, under Section 78 of the Law of Property Act 1925, LBA 1925. The benefit of a covenant passes with the dominant land if the covenant touches and concerns the land. Smith and Snipes Hall Farm Ltd. B. River Douglas Catchment Board, 1949, if both the covenantee and their successor hold a legal estate in the land, and if the original parties intended the covenant to run with the land. the benefit may pass via express assignment, requiring compliance with Section 136 LPA 1925, or via annexation, which automatically attaches the benefit to the dominant land. Statutory annexation under Section 78 LPA 1925 was confirmed in Federated Homes Limited, Mill Lodge Properties Limited, 1980. A scheme of development, Eniston v. Reacher, 1908, also allowed covenants to be mutually enforceable among landowners within a defined area. In equity, the benefit may pass by assignment, annexation, or a scheme of development, which are often applied more flexibly than under common law rules. Passing of the burden. Common law, the burden of a covenant does not pass to successors. Osterbury v. Oldham Corporation, 1885. Roan v. Stevens, 1994. In equity, however, under Tolk v. Moxhay, 1848, the burden of a restrictive covenant can pass if the covenant is negative, touches and concerns the land, benefits identifiable land owned by the covenantee, and the successor to the burdened land as notice of the covenant. Positive covenants generally do not pass, but indirect enforcement may be possible via the doctrine of mutual benefit and burden. Alsol v. Brazel, 1957. Discharge and modification. Restrictive covenants can be modified or discharged under Section 84(1) 1925 if the covenant is obsolete due to changes in the neighborhood, if it impedes reasonable land use without providing substantial benefit, if all interested parties consent, or if modification or discharge causes no injury to the benefiting party. Courts exercise discretion in these cases, balancing private agreements and public interest. Alexander Devine Children's Cancer Trust, BC Housing Solutions Limited, 2020. The Supreme Court emphasized proportionality and fairness in discharging covenants. Reform proposals. The Law Commission's 2011 report recommended replacing covenants with a system of land obligations, enabling positive and negative obligations to bind successors in a clearer framework. Although the proposal aimed to simplify enforcement and reflect modern land use practices, it has not yet been implemented despite broad support. Examination tips. Key considerations include understanding how benefits and burdens run with the land under common law and equity, differentiating between positive and negative covenants and their enforceability, analyzing leading cases such as Tolk v. Moxhay and Federated Homes, discussing the potential implications of reform proposals. Conclusion. Freehold covenants are central to land law, balancing private property rights and community interests. Although the existing rules are complex, they continue to play a vital role in regulating land use and maintaining property values. Ongoing discussions about reform reflect the dynamic nature of property law as it adapts to changing societal needs. Mortgages. A mortgage is a proprietary interest in land created to secure the repayment of a debt. It enables the mortgagee, lender, to recover the debt while allowing the mortgagor, borrower, to retain ownership and a right to redeem the property. The law of mortgages involves a balance between contractual freedom and protecting vulnerable borrowers. This topic explores the creation, protection, and enforcement of mortgages under both common law and equity. Creation of mortgages. Mortgages can be legal or equitable, depending on the formality and method of creation. Legal mortgages of registered land are created by a charge by way of legal mortgage under Section 23 of the LRA 2002. Requirements include deed execution under Section 52 of the LPA 1925 and Section 1 of the LPMPA 1989, and the registration under Section 27 of the LRA 2002. Without registration, the mortgage operates only in equity. In unregistered land, a legal mortgage may be created through a demise for a term of years, or a charge by deed expressed to be by way of legal mortgage under Section 85 of the LPA 1925. The first legal mortgage of unregistered land triggers compulsory first registration under Section 4 of the LRA 2002. Equitable mortgages arise where legal formalities are incomplete, but the agreement satisfies Section 2 of the LPMPA 1989, where mortgages secure equitable interests, such as a life interest or tenancy in common. An informal mortgage is created by deposit of title deeds, as recognized in United Bank of Kuwait v. Sahib, 1997. Equitable mortgages must be registered to be enforceable against third parties. Rights of the mortgagor. The mortgagor retains an equitable interest, known as the equity of redemption, allowing redemption of the mortgage upon full repayment. Courts protect this right against oppressive terms or attempts to delay redemption. Courts have struck down provisions that restrict the right to redeem, as in Fairclough First Swan Brewery, 1912, create clogs on the equity of redemption, as in Jones v. Morgan, 2001, or impose harsh or unconscionable terms, as in Cityland Property Holdings v. Dabra, 1968. Statutory measures such as the Consumer Credit Act 1974, as amended by the CCA 2006, provide additional protection against unfair credit relationships. Rights of the mortgagee. Mortgagees have various remedies to enforce their security. They have the power of sale exercisable under Sections 101 and 103 of the LPA 1925, allowing the mortgagee to sell the property when repayment defaults occur, provided they act in good faith and obtain the best price reasonably achievable, as established at Cuckmere Brick v. Mutual Finance, 1971. They have the right to possession, available immediately upon default, unless limited by contract or statute, as stated in Formaids Limited Fees Dudley Marshall, 1957. Possession proceedings involving residential properties subject to Section 36 of the AGA 1970, allowing courts to postpone possession if the mortgagor can pay arrears within a reasonable period, as in Cheltenham Gloucester, BS v. Norgan, 1996. They have the right of foreclosure, a rarely used remedy that transfers ownership of the mortgaged property to the mortgagee, extinguishing the mortgagor's equity of redemption. They can also appoint a receiver under Section 101 of the LPA 1925, enabling the receiver to manage income from the property without the mortgagee taking possession. Statutory regulation. The Financial Conduct Authority, FCA, regulates mortgages under the Financial Services and Markets Act 2000, focusing on residential mortgages, while the Consumer Credit Act 2006 governs second mortgages and buy-to-let arrangements, emphasizing fairness and good faith. Reforms and criticisms. Critiques of mortgage law highlight its complexity and inconsistency, particularly in distinguishing between legal and equitable mortgages. Proposals for reform include simplifying the creation and registration process, aligning protections for mortgagors across all types of mortgages, and addressing the balance between freedom of contract and borrower protection. Examination tips suggest understanding the distinctions between legal and equitable mortgages, analyzing the rights and remedies of both mortgagors and mortgagees, incorporating case law such as Cuckmere Brick, Cheltenham Gloucester v. Norgan, and evaluating the impact of statutory protections and reform proposals. Mortgages embody a dynamic interplay between property and contract law, balancing lenders' security with borrowers' equity of redemption. While significant protections exist, ongoing reforms aim to address modern challenges in property finance and ensure fairness within the system. Adverse possession and freehold title. Introduction. Adverse possession, often referred to as squatter's rights, allows a person who unlawfully occupies land to potentially acquire ownership over time, provided specific legal requirements are met. Historically, adverse possession reflected the principle that possession was the basis of land title, with statutes like the Limitation Act 1980 governing the process. However, the Land Registration Act 2002, LRA 2002, introduced significant changes, especially for registered land, entailing the ability of squatters to claim ownership. Adverse possession. Key principles. To establish adverse possession, two elements must be proven. Actual possession, demonstrating exclusive physical control over the land, such as fencing, cultivating or occupying a building. Powell v. McFarlane, 1979. Intention to possess, evidence of an intention to exclude the world, including the paper owner, from the land. A. Pye, Oxford, Lettered v. Graham, 2002. Possession must be adverse, without the permission of the paper owner. Any acknowledgement of the owner's title or permissive occupation halts the limitation period. EP Properties v. Buckler, 1987. Unregistered land. Under the Limitation Act of 1980, 12 years of adverse possession extinguishes the paper owner's title. S.17. The adverse possessor gains a new title rooted in possession, is subject to pre-existing burdens like restrictive covenants. Asher v. Whitlock, 1865. Registered Land Free LRA 2002. For the 13th of October 2003, adverse possession in registered land resulted in an overriding interest after 12 years, with the squatter entitled to register their title under S.75 of the Land Registration Act 1925. This process maintained the title's conclusive nature, but introduced complexities such as statutory trusts over the registered land. Registered Land Post LRA 2002. The LRA 2002 radically reformed adverse possession for registered land. No automatic extinguishment, Section 96, disapplies the limitation in 1980 to registered titles, so adverse possession no longer extinguishes the paper owner's title. Application for registration. Squatters with 10 years of adverse possession can apply to be registered as proprietors, Schedule 6. Land Registry notifies the paper owner, yet within 3 months. Exceptional circumstances. Even if objections are raised, the squatter can succeed in 3 cases. Estoppel, where it would be unconscionable to dispossess the squatter. Independent right, if the squatter has a separate proprietary claim. And boundary disputes, where the squatter reasonably believed the land was theirs for 10 years. 2-year grace period. If the squatter's application fails, they can apply again after 2 years of continued possession, provided the paper owner has not removed them. Human rights implications. In J.A. Pye, Oxford, Lettered v. UK, 2006, the European Court of Human Rights considered whether adverse possession violated the paper owner's property rights under Article 1, Protocol 1 of the European Convention on Human Rights. The court ultimately upheld the compatibility of adverse possession laws, emphasizing their role in balancing societal and individual property interests. Criminal Law and Adverse Possession, the Legal Aid, Sentencing and Punishment of Offenders Act. 2012 criminalized squatting in residential properties, PS.144. However, the Court of Appeal in Best v. Keith, Land Registrar, 2015, confirmed that criminal conduct does not preclude reliance on adverse possession to acquire title. Reform proposals. Critics argue that the LRA 2002 unduly complicates adverse possession, especially in registered land. Law Commission's 2018 report suggested refinements, such as clarifying the interplay between adverse possession and other proprietary claims. However, substantive changes remain unimplemented. Examination tips. Clearly distinguish between unregistered and registered land regimes. Discuss key cases such as Pye and Powell v. McFarlane to illustrate legal principles. Address the impact of human rights and statutory reforms in essays. Analyze problem questions by methodically applying the rules of adverse possession to the facts. Adverse possession remains a contentious and evolving area of property law. While its role in unregistered land continues largely unchanged, the LRA 2002 has reshaped its operation in registered land, prioritizing the conclusiveness of the land register. Despite criticisms, adverse possession balances the rights of landowners with the practical realities of land use and occupation. Thank you for getting to the end of this podcast. More on core FLK topics, look around Dr. Yannis' YouTube channel.